You're listening to the JSCN podcast, information and news for the Jewish small communities. Hi, I'm your host, Ed Horwich, and this is a special podcast on one topic, something that's at the top of a lot of organizations' minds. So whether you're a synagogue, a charity, a youth organization, a member group, or even a business, you're going to be having on your mind GDPR. That's the General Data Protection Regulation. In other words, it's data protection. And there is legislation, the biggest change for 20 years, coming into force soon in May. What do you have to do? Have you done it already? Have you done enough? Do you need to tighten things up? These are all questions that people are asking themselves. So, where do you start? I thought we'd ask somebody who has already made a presentation to a number of groups. Jon Benjamin came up to talk to the Jewish Volunteer Network, and so I nabbed him for the podcast. He has worked in some high-level roles. He's worked for UJIA, for World ORT, and has been CEO for the Board of Deputies of British Jews, and he knows our community very well. So we're going to concentrate on one or two examples to give you a bit of a clue, but you do need to go and check out the details for yourself and make sure that you have understood the data protection legislation in terms of your business or your charity or your synagogue. And I started by asking Jon, when does the legislation actually come into effect?
It comes into effect on the 25th of May. I think the first thing it's worth saying is that actually a lot of what people will be expected to do after that date is currently what they're expected to do now. So the current legislation actually dictates a lot of the ways in which people should be behaving with the data that they're processing.
Right. So what's the highlights, or one or two highlights, of what's new that they hadn't been doing before?
Well, assuming people have been doing what they should have been, and I think that's a fairly bold assumption, I think the emphasis really is on sort of substance and form. In other words, not just doing something, but also showing that you've taken the right steps, so that if anything ever went wrong, you could show that you have a policy in place, that you've thought about issues. For example, how long can you keep data? There are no hard and fast rules. It very much depends on the kind of data and what you're doing with it. But as a broad principle, you should only keep someone's personal data for as long as the purpose for which you collected it in the first place is still relevant.
So if it's a project, it would go up to the end of the project, or if it's a newsletter, you would only keep their data for as long as they were subscribed to the newsletter.
Yes, so I mean, the trick is to get people to tell people as much as possible about what you would like to do with their data, to put them on notice, to not spring any surprises on them, sort of Cambridge Analytica style. And that way, the sort of tacit permission that you then have would allow you to keep data for longer and use it for sort of broader purposes. For most organizations, they're fairly set in what they need people's data for, but there may be something that comes up. There may be a bit of marketing or telling people about an event or a campaign that perhaps wasn't anticipated at the outset. But if you've covered that off in broad terms, in terms of telling people the sorts of things you might do with their data, then you should be fine.
Okay, so do these rules apply just to private individuals, or do they apply to business or organisation, like one charity to another charity?
Yeah, look, starting with the most general principles, I think this is, if people have a kind of intuitive feel for what this is about and who it's there to protect, then everything sort of falls into place. As you say, it's about protecting the rights to privacy of ordinary individuals like you and me, and obviously that can relate to staff at an organization, to volunteers, to people that you engage with, to customers of a business, to members of a club, whatever it may be. But people whose private personal data, names and addresses and other information about them, payment details, for example, are being handled by an organization. That's essentially what the regulations are there for. And if you think that the regulations apply to everyone from a small community somewhere in England, or Amazon or Expedia or Facebook, as we've seen, the same set of regulations apply to everyone. And the trick is therefore trying to make the regulations fit for you as an organization, bearing in mind the kind of resources that you have and what you're doing with the data.
Right. So I think the most interesting thing for our listeners is the people who are running events either in a charity or a not-for-profit group or in a synagogue, in a shul or a shul group or a youth organization, something like that. So, for instance, a synagogue could interact with a school because of running a school visit talking about Judaism, something like that. So if a teacher gets in touch with them, do they need to get consent to store that teacher's details in case they need to follow up later on?
Okay, inevitably your scenario sort of actually brings in a number of issues, but on that particular point, and this is the question you actually asked before about business to business, and obviously business to business doesn't necessarily mean in the commercial sense, where you are dealing with an individual in their role as an office holder or a holder of a position at another organization, then you are, albeit that you have their email address and it's the email address of that organization, that is a kind of a business to business relationship. So you can hold on to that data. In any event, you are dealing with someone because you have a legitimate interest. In other words, you have, as an organization, an interest in processing that data. You don't need their consent for that. Although if they said, please remove me from your list, leave me alone, you'd have to adhere to that. And that would be true in a business to business setting as well. So in a way, the business to business or the sort of the private rights kind of overlap to a degree. But right. As far as the teacher is concerned, you can certainly hold on to their data unless they said otherwise, and you can use that to contact them in future. If the teacher then sent you a list of the kids, because it's a synagogue and perhaps for security reasons, you need to know a list of the children and perhaps the other teachers that were coming along. That data you would not be entitled to keep beyond the visit, because that's the simple purpose for which the data was given to you. And in fact, in that case, you as an organization will be what's called a data processor. In other words, you're handling the data on someone else's behalf and not as the principal processor, the handler of the data.
Right. So staying with synagogues.
Yeah.
The synagogues have memberships. Those members have been on their books for a long time. Over the recent years, they've probably collected the email addresses of their members. Is being a member different to being an individual, or do synagogues have to go to their members and ask their consent to send them the regular weekly, monthly newsletter?
Yeah. Okay. So just to unpick this slightly, I certainly want to come to your question because it's a fundamental one, but there are different reasons for which any organization is allowed to process data. When I say process, I mean collect it, store it, use it. And one of those legal bases in the regulations is that you have consent. Someone has said you can do that, do what you want with the data, or that you have, this is the phrase I mentioned before, legitimate interest. In other words, you as an organization, be it a charity or a membership organization or a business even, you're allowed to do what you do as a charity or a business in order to raise money or make money for your company. And your legitimate interest then has to be balanced with the rights of the individuals. And then a third, their rights to privacy. So you couldn't, stalk people or send them lots and lots of unsolicited material. Another basis would be that you have some kind of contractual relationship. Now, for a synagogue or a membership organization, it's possibly that you have legitimate interest. In fact, you certainly would have a legitimate interest in providing a service for your members. It may be that there is a contractual relationship, although you then get into the issue of whether there is actually a contract for services, because a lot of synagogue subscriptions are gift aidable, so it's a slightly knotty area in that actually it's a charitable donation, so it can't therefore be sort of a contractual obligation to pay synagogue dues, but that's that may take us down a bit of a blind alley. Right. But the point that you raise about emails is irrespective of the legal basis that you have for processing people's data, and I don't think anyone should be worried that there is a legal basis, whichever one it is. You need specifically to have consent to send people emails that contain any kind of marketing or promotional or fundraising content. And that's actually because of a separate regulation, the Privacy and Electronic Communications Regulation, which says you can't email or text people or send them automated phone calls unless you have specific consent. So even if you have a legal basis for processing their data, having them on the database, sending stuff to them by post, you can only email them marketing or promotional material if you have consent.
Right. So, practical question. Do all synagogues now have to contact their members and get that consent?
The simple answer is yes, because I mean there may be a question as to, well, what are we sending people? Is it just about Shabbat times and information that they as paying members expect to get? This is the service essentially they've signed up for, and that may be right. That may actually mean that you wouldn't need. You're not sending marketing material, but the moment that you include anything that could be seen as marketing or promotional, then you're immediately in the territory where you would need consent. So it's much safer and better to know that you have consent, and therefore you're not going to be in any kind of difficulty. The example that the Information Commissioner, who is the regulator for this area, gives is a bank that sends customers by email bank statements, which of course is a service the customer would expect. And on the bottom of the statement, the bank says, have you heard about our new mortgage products? We're offering great rates. That would turn a simple bank statement, a piece of information for which the customer is essentially contracted to receive, into a piece of marketing material. So the moment you, as a synagogue, say, okay, here's your bill, and by the way, come to our Lag BaOmer fundraising barbecue, only £25 a ticket, that would then turn it into sort of marketing or fundraising material. So in order to be able not to be sort of worrying about the content of your emails, it would be better to collect consent.
Well, that's very clear. Now then, one of the other things is that people need to construct, or in fact, do they need to construct a privacy policy? Can you tell us a little bit about that?
Yes. Well, the privacy policy is essentially the go-to document that tells people what you are doing with their data. So you'll see if you go onto lots of websites that there is a privacy policy, and some of them are more or less fit for purpose. But essentially it's saying, we collect your data. This is why we collect it. We have a legal basis for doing so. And these are the kinds of things that we'll be doing with your data. Now, the more upfront you are with people, and the more you tell them in simple, plain English, the less they can complain that they didn't know what you were going to do with the data. So the purpose of the privacy policy is just as a general piece of information. And where you're collecting consent, where you need consent, as I say, for marketing or promotional material sent by email or text, then the consent has to be informed. People have to know what they're signing up for. And again, if you flag up the privacy policy when you're collecting consent, when you're saying to people, okay, please subscribe to our newsletter, or please join us as a member, whatever it may be, here is our privacy policy, then you've covered yourself off. You've told people exactly what they're doing. So another example may be that someone comes to a one-off event, and they're not a member, you've got no interaction with them, they might come along as a guest of someone else, and you say at the end of the evening, please give us your details, we'd like to know who was here, we'd like to keep in touch. If at that stage you told people about the privacy policy, and they sign up and they give their email address, then basically you can comfortably add them to your database and communicate them with them in future. What you might actually do is, if they're just given an email address, is write to them by email afterwards and say, thank you for signing up, glad you came to the event, hope you enjoyed it. Here you can find a copy of our privacy policy online, but that way you've covered yourselves with the information you've given to people.
So the latter example is probably more practical, rather than put a printed copy of your privacy policy next to the sign-up sheet, which...
Absolutely. Well, the example that someone gave early on was, you go to these events where you can win a bottle of champagne if you leave your business card. Now, actually, most people are leaving their business card because they want to win a bottle of champagne. And if they don't expect to receive, mailings from double glazing companies. But if, it's a matter of sort of taking what is clearly consent for one purpose and turning it into a broader purpose by just being open and transparent with people.
Right, okay. So now then, going on to the practical or technical side of things, when you're collecting this data, how are you allowed to store it? Do you have to print it all out? What do you do?
Okay, so personal data, which is covered by the regulations, is anything that either identifies an individual or can be associated with an identifiable individual. So obvious things like names and addresses, credit card details. It may be that you need to do a bit of adding 2 and 2 to make 4 to get the information to understand who it relates to. But it's what you and I would understand as our personal information. It includes also things like photographs or comments about someone. So if you had on someone's data record, they're a poor player or they're an awkward so-and-so, that potentially would be disclosable were they to ask for the copy of the information you have about them. So it's worth being respectful and sensible in what you say about people. Now that data can be held in any which way, electronically or hard copy files, but obviously it has to be kept securely. So going back to basic principles, when you're protecting people's privacy under the regulations, you also have to protect the security of their data. So you have to have a legal basis for processing the data, and you have to make sure that, assuming that you do have that legal basis and you have consent and if you need it and so on, that you're looking after people's data securely. So, the normal kinds of checks and balances one would expect to see, computers should be password protected. The difficulty, I think, comes obviously because nowadays we're sharing data even as individuals from one device to another on our phones and on our tablets, and it's portable, is that all our devices should be as secure as reasonably can be. And if you're talking about, for example, sending a list of data, so a database or a spreadsheet detailing all the people that are coming to an event, then you have to be particularly careful that who that's being sent to and that they are aware of their obligations to keep it safe, and where possible actually not send downloadable data but sort of keep it on some kind of cloud-based or web-based platform, so people have to actually sign in to get it rather than have it sort of knocking around on umpteen different devices. So that security aspect is important, and as I said before, coupling that with only having data for as long as and for the purposes that you collected it in the first place means that when you think about it, the more places where someone's personal data may end up, the more difficult it is then to delete it or update it down the line. So you see lots of charities, again, with volunteers, with trustees, with people who are running events, great people that help our community do the wonderful things it does. But you can imagine how many laptops are there, how many phones, how many devices are there knocking around with event lists from 2015 and who came to such and such
so it really needs one person to be in control of where that data is going. Now then, there is a term which that people will come across, which is data controller, the data controller. What does that mean? Does that mean one person, and who should that person be, or does it mean something else? Does it mean an organisation?
No, the data controller is the principal organisation that is responsible for someone's data. So if you are a synagogue, for example, you are collecting members' data, you are the data controller. You are the organisation with whom the individuals have the relationship. You may be a data controller even if you don't actually have a formal relationship with someone. If you're a charity that has identified potential donors, you might not have the relationship because they may not have made a donation, but you are essentially the principal organisation that is handling that data. A data processor, as I mentioned before, not to be confused with those little things that go in our computers made by Intel, a data processor is someone acting on behalf of the data controller, a third party. It may be an event organizer, it may be a print company to whom you've sent a database, a list of people because you want to send out a mass mailing, so they would be a data controller. But working for the data, so they would be a data processor, sorry. Working for the data controller would be staff potentially and volunteers, and they are all deemed as part of the data controller. So the data controller operates through all the people who are directly working for it.
So you were just talking about sending data to a third party, like somebody who's going to print out your mailing or
Rosh
whatever
Hashanah
it
mailing
is.
or whatever, yeah.
What controls what they can do with that data?
You need to have a very clear understanding. First of all, you should do a bit of due diligence. As you would imagine, you wouldn't want to share sensitive data. It may just be names and addresses. It's not going to be anything else necessarily, but that's clearly and obviously personal information. You would want to make sure that you're not sharing that with just anyone. So a little bit of background checking. Does this organization itself have a privacy policy? Does that show that they understand their legal obligations? And if they seem to be, fairly pucker and sensible, then you would want to enter into a third-party agreement with them that sets out precisely the nature of your relationship. Now, it doesn't happen all the time by any means, but you would hope that if you are doing business with a company that's providing you any kind of services, you would have some kind of contract. And if it's not included in there, then it's easily done. I supply these to lots of people. A short third-party agreement that says you will be receiving certain personal data. You only have this for the purposes for which we have given it to you, which are as set out, and you must delete it or destroy it to our satisfaction at the end of the job, and that you would be liable if we suffer any loss by virtue of your being in breach of this agreement or your sort of legal obligations. So essentially, they are an agent for you. You are responsible as the data controller for everything the data processor does or doesn't do, but you should put them on notice as to that fact so that they obviously behave responsibly.
Right. So are there any other points that people should consider or read up on about the GDPR?
Well, you mentioned before about is the data controller a person? It is sensible within any organisation to have someone who you might call them the data protection officer or data protection lead. It's not obligatory for most organisations, but just to have someone who actually does sort of get up in the morning and give this some thought. Although everyone working for an organisation needs to, act in the appropriate way with the data they're handling, the data protection officer or lead would be the person that would make sure that the organisation is being compliant. So it's as well to have someone that is a little bit more clued up. And obviously, if they need to sort of seek outside advice, they can do that. There are lots of websites. The Information Commissioner's own website is a source of information, although, as I say, it's very general in the way that it's set out, because it's for all the organisations, many thousands of them in the country that are bound by these regulations. So, I think the practical things are to have a privacy policy, to have a means of telling people, through the privacy policy on your website, what you are doing with their data, to collect consent, which needs to be by way of a positive opt-in. It needs to be ticking a box or someone consciously filling out a field in a sort of an online application, saying, I understand what you're going to do with my data. I've read the privacy, or I've seen the privacy policy. So you need to, go through that process, because, as I said right at the beginning, the thing about GDPR is not only doing the right thing, but being able to show that you've done the right thing.
Just going back to one of those points that we've mentioned it a couple of times now. Somebody goes on and they fill in a form on the website, and they tick the box which says, "I've read your privacy policy," and it's fine. Are there any instances where you need to pick out a specific thing that you need to make somebody aware of at that point, rather than just include it in the privacy policy?
Well, the privacy policy normally runs to, obviously if it's online, doesn't look like 3 pages. Sort of a decent length one, without it being too long, is 2 or 3 pages. And that will tell people kinds of things you're doing with their data, that you're collecting it for the purposes of their membership, or because you're sending a newsletter or updates. We may write to you from time to time about campaigns and activities we think you'll be interested in, that kind of thing. So that should be fairly sort of clear and plain. If there's anything specific that you want to do with someone's data, then I guess you can be more upfront. And what you will do very often on a website is have something called a privacy notice, which is a much shorter 2 or 3 lines notification to people to tell them what you might do with their data. That will then include the longer privacy policy in it as a link. So the privacy notice may say explicitly, we will use your email address. You know, someone signing up as a member of a synagogue, they will expect that their data will be used in certain ways. But if you wanted, for example, to say that we are linked with a community in Ukraine, we're raising money for them, we would like to write to you from time to time with information about Lvov or whatever it may be, then you might want to put that, give that a little bit more prominence in there. But you know, that's something that could be dealt with in the privacy policy as well.
Just to sum up, then, shuls or similar organisations were probably wise to contact their members and ask them for consent, make the privacy policy clear to them with a link or something like that. Just get them to check them to read it. And then that probably covers them in general. But then when they have something specific, then they might just need to get consent for that specific thing.
Yeah, if you're going to do something with people's data that they are not otherwise expecting, then it's as well to tell them and to give them the opportunity. You always have to give people the opportunity to opt out or unsubscribe anyway. So you might want to flag it up. But a decent privacy policy will cover pretty much everything you want to do. You don't want to have to keep going back to people and asking for their permission or their consent, or to drive them sugar, because ultimately, as much as the Information Commissioner may say you should get sort of granulated or layers of consent, and people should consent to emails and posts and all kinds of different communications means, actually that's a bit of a turn off for a lot of people, and they may either ignore it or opt out or whatever. So I would suggest keeping it fairly simple and straightforward. And the other thing, just to mention, is about retention. How long you keep the data for.
Yeah.
And as you said earlier, if someone is clearly a paid up member of a synagogue, then you can certainly keep the data for that long. And even if they stop, probably for some period afterwards, there may be issues around gift aid. So you'd be entitled to keep records relating to gift aid for up to 6 years. A former employee, you would normally keep employee records for up to 6 years, because there may be any kind of comeback. You have to look at the different kinds of data you hold and take a view on what your retention periods are for those different kinds of data.
Well, just to look at what people will have seen coming through their own mailboxes, they've probably seen consent notices coming through from organisations now as we're leading up into this. Is it the 25th of May when the legislation actually comes in? And they're probably thinking, you know what, I signed up for that thing about 3 months ago or a year ago, and I'm sure they asked me to tick a box then. Why am I having to tick a box one more time?
Right. Yeah, well, probably because the sign up 3 months ago or 3 years ago, or whatever, was didn't necessarily meet the standard that would now be expected. So, as I keep saying, GDPR is as much about form as substance. And if the organisation was ever put to proof to show that the people that signed up actually had seen a privacy policy and had ticked a box, in other words, adhered to all the sort of the consent conditions that are now required, the organisation may not be able to show that. So they're probably going through the process again, just to make sure that the consents they have are absolutely above board. And it's as well to do that. Obviously, if you've got exactly the same email and you gave your consent 3 weeks ago and they've written to you again, it's probably just that they haven't taken you off the round robin email to note that you've given consent. I mean, clearly organisations need to record that consent when they have it, and not to again drive people crazy by asking for the same thing over and over again.
Right. Now then, a couple more things. A number of organisations will use a third-party online system to process for instance, their newsletter. So MailChimp and similar services are very commonly used, and data will be stored in their system on their server somewhere in the cloud. Who knows where it is? Yeah. Are people okay using those services?
Well, yes, broadly, subject to everything we've seen with Facebook and so on. Now, Mailchimp, for example, is an Atlanta-based company, Atlanta, Georgia, in the United States. So it's actually an issue that the information is going outside of the European Economic Area, but the United States is considered a fairly safe jurisdiction. But as I said before, it's like the mailing house or anyone else you might share data with. You need to check that they are fairly reliable. Someone like MailChimp or Constant Contact, one of these mailing sort of web-based platforms, are considered as safe as any of these things are, and who knows what they actually do. I mean, I've looked at their privacy policy, for example, and it says all the things you would expect. Now, MailChimp, for example, essentially say that we are a data processor. In other words, we're acting as your agents, and that we will only send people emails off your list because you tell us that those people have given you consent to receive those emails. So MailChimp, in a way, saying we're acting for you on your instructions, which is as it should be, because essentially that's what they are doing. And they will say in their privacy policy, we don't share or sell the data to anyone else. It really is your data that they are just handling for that specific purpose.
If I'm right, I think I've read they do have special processing facilities for companies and organisations based in Europe.
In your privacy policy, you will say, we will only share it with trusted third parties who adhere to privacy policies that are at least as stringent as ours. If we send your details outside of the EU, then again, we make these same sort of checks.
To round off, I think, where can people get help? I think the ICO, the Information Commissioner's Office, you mentioned their website has a lot of information. Some of it is a little more specific, I know. I think they have a helpline, which is bound to be getting busy, but I think at the moment you can get through to it. Are there any other ways people can get help with this?
Ultimately, the Information Commissioner is the regulator, so everyone has to defer to them. If you are a fundraising organisation, a charity, you might look at the fundraising regulator's website, but essentially they are only putting into practice what the regulations in the Information Commissioner is ultimately responsible for. So, you can read around. It's better, I would say, to go to the sort of the core material, so the Information Commissioner, rather than people who set themselves up as consultants, publishing articles. There's a guy called Tim Turner who is very good, who is a consultant. He may be worth sort of looking him up and seeing what he has to say. And to be honest, there's still a lot of grey areas. The Information Commissioner publishes guidelines, and the thing about guidelines is they give you latitude, they give you examples of, in different instances, how you might behave, but they don't tell you exactly what you must and mustn't do. So again, when we come to retention periods, it won't tell you exactly how long you can keep every piece of data for. You use your judgment, and some people like having that flexibility, and some people need to be told, well, just tell me what I'm supposed to do. So in a way, it's a matter of finding your way. But if you essentially have acted within a sort of sphere of reasonableness, if what you've done, if ever you had to explain it, you feel that you could explain it, that we thought about it, we came to this view because we had these criteria that we were considering, then you've been through a process that means that you've given due consideration to what you're doing with people's data. So if something went wrong, and it could be leaving a laptop on the bus, leaving a file on the train, what would you wish you had done at the time if you thought about it? Do everything you can in your power to make sure that people's data is safe, is protected, have processes in place if something goes wrong to try and fix it. And, if ever it came to any kind of investigation by the Information Commissioner, which is hugely unlikely, but you never know, what would you comfortably say to them you did to minimize the risk of a data breach or the impact of a breach if it happened?
So for May the 25th, it's not a case of we have to have everything locked down in a certain set of rules and so on and so forth. As long as you have made sufficient effort to put a policy in place and to actually put that into action, and you've checked with things like the ICO website and any specialist information if you're not sure. As long as you've done that and you're recording it and recorded what you've done, and you have your records secure somewhere, whether they are on your personal computer or whether they are locked down within something which tells you that it's been locked down, then you're probably okay and you have taken reasonable steps, and nobody's going to penalise you just because you didn't put a comma here or a full stop there.
Yeah, as I say, there's a lot of latitude, and a lot of it is common sense. And I suppose the way to think about it is just methodically go through, well, okay, what kinds of data have we got? We've got staff, we've got volunteers, we've got members, we've got people who are coming to events. What do we do with that data? Do we have a legal basis for having it in the first place? Have we told people or given them the opportunity to find out what we do with their data? And then what are our policies going forward in terms of how long we keep it and how securely we keep it? So to document, to have just literally a spreadsheet with 5 or 6 columns or lines covering the different kinds of data, and this is membership information, we keep it for X number of years. This is staff data, we keep it for X number of years after someone's left. There is actually a methodology, there is a process involved in everything you do with people's data, from collecting it in the first place to deleting it at the end of the day. Yes, then you've shown that you're thinking properly, and it's actually a good discipline, really, to think through what you're doing with the data and to look after it in the appropriate way.
Jon, I think that's given us quite a lot of information. People will probably want to play this back over and over again to remind themselves about it. But that's the beauty of being online and being permanent there with the information. And go and have a look at the Information Commissioner's website, which is ico.org.uk. Phone them up if you need to, if you can get through. And if you need anything specific, then look for a specific source of information which is going to give clarity to it. If you want to find out more about Jon Benjamin, his background and his work, just go to his website, which is mjbconsulting.biz, and that is B-I-Z. The other source that Jon Benjamin mentioned was Tim Turner, and you can find his free guide, which can be downloaded from his website, which is 2040training.co.uk. That's 2040training, all one word, .co.uk. And he has 2 downloads there, which you'll find under the download menu link. One is called Fundraising Data Protection Guides, and the other is called DPO Guide for Contractors. And of course, don't forget the Information Commissioner's website, which is ico.org.uk, and that is the source for all official guidance. You'll find their helpline chat link and their helpline telephone number there. So if you found this of interest, please do let me know. Email to me, Ed Horwich, hello@jscn.org.uk. Please go and visit our website, jscn.org.uk, and we'll be back with our regular podcasts and our monthly omnibus roundup from communities all over the country, and lots of information and news. Look forward to speaking to you, hearing from you. See you next time.